Hi, my name is Ángel Calleja. I'm a partner with Garrigues Law Firm, and I practice international law. And I would like to share with you some ideas on the current international and global law practice. Can we speak of global law? Indeed we can. Global law is today a reality. Global law is the matter which most of us practice when we try to accomplish business results in many of the global deals that most of our agents, economic agents, are conducting and implementing around the world. There are two basic concepts of law. There are two main different ways of understanding, two main different systems to apply law worldwide. One is the Anglo-Saxon, also denominated case law. The other is the civil, also denominated code law, which is typical of the continental European system. Both systems coexist today in the current world, and the principles existing in both of them need to be applied to transactions and deals around the world by law professionals. Global law, however, is mostly defined, is mostly influenced by Anglo-Saxon case law. One could say today that Anglo-Saxon case law is succeeding in this challenge between Anglo-Saxon and Napoleonic law. Why is this? There are different reasons why. One would guess that today the case law system is prevailing over the code system. One is obviously the language. English is the language of business. English is the worldwide language. And English is also the language of case law, as opposed to different languages in which continental or civil law is applied. Number two, there is a clear predominance so far of the Anglo-Saxon system and culture in the business world. Number three, the model to conduct business in the world through multinational enterprises is an Anglo-Saxon contribution to the business world. Due to all these reasons, and also, most importantly, to the fact that the Anglo-Saxon case law is much more flexible and its principles may be better spread, results in the consequence that Anglo-Saxon case law is prevailing over civil law. But one must never forget that both prevailing systems are rooted on the same Roman law principles. Therefore, it is not impossible to reach the proper conclusions, whatever the knowledge, the technical background a lawyer has, when one makes the effort to converge between both systems. Therefore, in today's world, the challenge for a global lawyer is to make sure that his local background, his local training is not an obstacle in practicing globally. In other words, we are locally trained to globally practice. And that is our challenge. And that is what it makes necessary today for a lawyer to supplement its local knowledge, its basic training as a lawyer, with supplementary training, supplementary background in the other legal system. It is no longer acceptable for a lawyer to be proficient only in the civil law or case law system where he was raised as a lawyer. In today's business world, lawyers are required to have a fair command of both legal systems, a fair knowledge of how each systems work, because the demand of the market will be for him to practice within both systems in the international business praxis. Let me briefly illustrate this point with an example. Every time a European company goes to the US and attempts the purchase of a listed US company, and this is a matter on which we have drawn broad experience in the last years, there needs to be accomplished a number of very sophisticated legal engineering to ensure that the legal consequences and risks are addressed. For example, the tax interests of shareholders across the Atlantic are typically met in different points in time. We would not want to anticipate US taxes because European taxes will be deferred or the other way around. We may need to make sure that tax neutrality protection is awarded, and this involves tax experts in both sides of the Atlantic. But more than this, we need to address the proper timing of the shareholders' meetings in both sides of the Atlantic to accomplish the transaction. Thus, the transaction will not work if a decision at shareholder level in the US as a purchased entity is not binding for those US shareholders in respect of the purchases plan of the European company. Unless true, deep US knowledge is combined with deep commercial, technical knowledge in Europe, there is no way the objectives can be accomplished. In this type of cases, it is very frequent that the lawyer has to address at the same times and with similar contents the requirements both of the US Securities and Exchange Commission and at the same time through the brochure to be filed in the European country where the shares of that purchasing company is listed. Again, due coordination must be had to ensure that the same consistent economic shareholder messages are delivered across both organizations, irrespective of whether the specific contents each of them require is different. This is a tremendous effort for lawyers because the answer, I really cannot deal with US issues for a European lawyer, or I really cannot deal with European issues for a US lawyer, is not acceptable because the transaction simply would not go through. So what is the international business practice? International business law is part of global law. It doesn't collide with global law. It supplements global law. And it is a praxis developed by practitioners who endeavor to make possible the completion of global deals throughout the world. It has to do with the proper harmonization of issues, risks, and legal solutions to different problems that crop out in the implementation of business deals throughout 180 plus countries in the world, each of them with its legal system. Therefore, it is essential for a lawyer in the 21st century who wishes to practice in this global business landscape to be able to anticipate issues, to be able to sort out problems, and to acquire an experience in the cross-border world that enables him to add value to every transaction he is involved with. This set of challenges is very demanding for strictly local trained lawyers. This set of challenges require brand new different skills and require an enhancement of existing skills in respect of the work to be accomplished by lawyers. This is what the high end of the market is demanding from lawyers today.